Hello, and welcome to the Point Loma Democratic Club podcast. The October 2021 meeting of the Point Loma and Ocean Beach Democratic Club discussed crimmigration, the intersection between criminal law and immigrant law. This podcast is made possible by the generosity of our members. Consider becoming a member by signing up on our website, pointlomadem.org. Diane Mosley, Vice President of the Point Loma and Ocean Beach Democratic Club, introduces the panel of speakers.
Today's talk is going to be very interesting. It is on the subject of crimmigration, which is the juxtaposition of criminal law and immigration law in this country. And we have three speakers today. Our Point Loma resident, Jerry Wasson, who's been working as a federal defense attorney for approximately 30 years, will join us, as well as Andrew Nietor, who's the chair of the local Immigration Lawyers Association. And our third speaker is Odd Ruffing, who is an immigrant as well as a lawyer defending immigrants' rights. So at this point, I will hand it over to Jerry to give us a short presentation.
Thank you, Diane. Hello, everybody. I'm glad to be here today. What I wanted to speak about was what exactly crimmigration is. And as Diane said, it's where criminal law meets immigration law. And basically what that means is the prosecution of unauthorized entry into the United States. And why this is an important topic, I think, is because immigration-related offenses consist of the large amount of federal prosecution. The Justice Department statistics showed in 2018, immigration-related offenses comprised of nearly 70% of all federal criminal prosecutions in the United States. And the vast majority of those prosecutions, of immigration-related prosecutions, involve what are called illegal entry or illegal reentry cases. And that is when a person who is not a U.S. citizen simply enters the United States without lawful permission to do so. Typically, it means without the lawful documents, immigration documents. That's illegal entry. The other offense that is most commonly prosecuted is illegal reentry. And that's typically the same offense, except it also involves a person who's previously been deported. So they're not a U.S. citizen. They don't have proper documents. They enter the United States after already having been deported once previously. The difference between the two is that illegal entry is a misdemeanor offense and illegal reentry is a felony offense. The difference between a misdemeanor and a felony offense is a misdemeanor offense has a maximum sentence of in custody of 1 year or less. In a felony offense, the maximum sentence is greater than 1 year in custody. Those aren't the maximum sentences for those offenses. That's the definition of a misdemeanor versus a felony. The maximum sentence for someone just simply coming into the country without proper documentation is 6 months in prison. For a illegal reentry case, it's either 2 years, 10 years, or 20 years in prison, depending on what their criminal history is. So that's the different offenses that when we talk about unauthorized entry into the United States, there's other ways to commit that offense through document fraud or making a false claim to U.S. citizen, saying you're a U.S. citizen at the port of entry when you're not. But those are not the typical cases that we see. The vast majority of these cases are these illegal entry or illegal reentry cases. So who are we prosecuting here? Well, the statistics show from the U.S. Sentencing Commission that 99% of these cases involve Hispanics. 97% are male. Their average age is 36. And this is going back to 2016 through 2020. And the vast majority of them, well, not the vast, but the majority of them have no or very little criminal history. And what I mean by criminal history is any prior criminal convictions that they have. In 2020, fiscal year 2020, 66% of the people that were prosecuted for either illegal entry or reentry had no or very little criminal history. And when I say little criminal history, what I'm talking about is typically traffic tickets or driving on a suspended license, something of that nature. In 2016, that number was 50%. And the percentage of people who have what I would call serious criminal history is a lot less. In 2020, of all the people that we prosecuted for these offenses, only 5% of them had a serious criminal history. And when I mean serious criminal history, what I'm talking about is more like drug offenses in the past, possession or possession for sales, or burglary offenses, robbery offenses, something like that. It's a misconception that I hear from my friends all the time, like, oh, don't we only prosecute the murders and rapists that come into the United States, and don't we just let the other people go? It's like, no, that's not true at all. It's really rare to see a person who's been convicted of a murder offense or a rape conviction to be prosecuted for illegal reentry. We just don't see that. In my 30 years of practice, I maybe only had a couple of those people, of the hundreds and hundreds of these people that I've represented. So the vast majority of them are, at least in 2020, it was 66%, are had no criminal history or very little criminal history. But surprisingly, their sentences their sentences are about the same throughout. From 2016 to 2020, their average sentences are around 8 to 14 months in that time frame. And also, their conviction rate is around 97%. So, which means of all the people who were charged with these offenses, 97% roughly were convicted. Their average sentence that they received is around 8 months. It was 14 months in 2016, but it averaged in that time frame between those two numbers. So, in my experience, the typical client that I get in these kind of cases are a mid-30-year-old male, a Mexican male who is a construction worker or a landscaper. The vast majority of my clients in these cases fit that profile. And the females that I've represented, they're not many, but they tend to be house cleaners or hotel workers, nannies, people like this. It's a misconception that we're only prosecuting the very dangerous people that come into the United States. That's just not true. And it's also a misconception that these people are not doing any prison time when they get arrested and charged with these offenses. That's not true either. A couple other misconceptions I'd like to dispel is the notion of zero tolerance and open borders, or just total catch and release. Those to me, I'm sure Andrew can talk to this better, but they don't really exist in my world, what I've seen. During the Clinton administration, under Janet Reno running the Department of Justice, there was Operation Gatekeeper, which enhanced or greatly increased the number of prosecutions for illegal entry and reentry. And the same thing occurred in 2019, 18 and 19, under the Trump administration with Jeff Sessions started Operation Streamline. And actually, Operation Streamline started during the Bush administration, but in a very limited capacity. And what the Trump administration did was greatly increase that or enhance that. The reason why that's not zero tolerance is because there's a finite amount of resources that the criminal justice system has. There's a finite amount of detention cells, holding cells, courtrooms, judges, marshals to transport these people, lawyers, prosecutors. So there's no way that the criminal justice system can have zero tolerance on everyone who has an unauthorized entry into the United States. It just can't be done. We just don't have the infrastructure or the resources. So there has to be decision-making process from the Department of Justice is on how many people we prosecute, who we prosecute, and what happens. And so it's been fairly consistent since the Clinton administration, the numbers, as far as the number of prosecutions. And again, these are the vast majority of all federal prosecutions. It did spike in 2019 under Operation Streamline. For example, in 2016, the fiscal year 2016, and President Obama's last term, there were 15,000 prosecutions for illegal entry. In 2017, it was 15,000. 2018, 18,000. It spiked up to 22,000 in fiscal year 2019, again, due to Operation Streamline. But by 2020, that went back down to 19,000. So it's been fairly consistent as far as the numbers of prosecutions. The people being prosecuted, again, it's very consistent on what we're seeing. And their sentences have been relatively the same as well. And so that's basically has been my experience. I welcome any questions that anyone has about these prosecutions and what happens here. Thank you.
Thanks, Jerry. Can we now hear from Andrew? Do you have a few opening remarks?
Sure. My name is Andrew Nietor. Thanks very much for inviting me to the meeting this afternoon. I'm a local attorney. I live in North Park and I work downtown. And I've been practicing mainly immigration law for a little over 21 years here in San Diego. We hear a lot about asylum in the news and what's happening at our border here in San Diego, the increase in Central American refugees, the Haitians in Texas from last month. So I thought I'd start by talking a little bit about asylum because it's a term we hear a lot, and I think there are some misconceptions about what asylum is and how you obtain it. Just to speak very generally, when somebody applies for asylum, they're basically saying that they have a fear of being persecuted in their country of nationality on account of 5 very specific things. It has to be based on race, religious beliefs, political opinion, national origin, or membership in some type of particular social group. So that could be somebody, for instance, fleeing from Cuba because they were threatened for their political activities against the current regime. It can be somebody from Iran because they can't practice their faith, a family fleeing Guatemala because of being persecuted based on perhaps being an ethnic minority, somebody from El Salvador or Mexico because they're being targeted by gangs who are working with the local law enforcement. So those some of the more common bases that people would claim asylum. So that's the law on asylum, and that's all codified in U.S. law passed by Congress. And the law also lays out how somebody is supposed to apply for asylum, and that's where there's very often a conflict between what is supposed to happen and what actually happens. So as an example, someone in, say, Mexico or Central America or most places around the world, if somebody wants to apply for asylum, they can't just go to the local U.S. embassy and say, I'd like an application for asylum, please. They actually have to make it to the U.S. border. And then the U.S. law, which and also international law, says that if somebody comes to our border, for instance, the San Ysidro Port of Entry, the CBP inspector the Customs and Border Protection, is supposed to ask somebody, obviously, do you have documents to come into the United States? And if they say they don't, then they're supposed to be turned away, unless they claim a fear of being returned because of persecution. In other words, they have a basis for asylum. And at that point, the CBP officer, instead of returning them to possible persecution and death, is supposed to at least temporarily allow them to come into the United States so their asylum claim can be heard. Now, what happened during the Trump administration is that they essentially ignored all those requirements, as in the law, and refused to let almost anybody in, even if they had a legitimate fear. And that created this massive refugee settlement across our border in Tijuana and all across the border, California, Texas, all these essentially refugee camps that included refugees, families, and over time, as people were there for weeks and months, they essentially became desperate. They were being targeted by gangs and smugglers, and many of them started, because they had no choice, started going further east from San Isidro and Tijuana into the desert and trying to cross over for the purpose of applying for asylum, by the way. And now enter the Trump administration's Operation Streamline and zero tolerance, the family separation policies, all those things, some of those things Jerry mentioned, and many of those things you remember from a few years ago. And those refugees are now being charged with federal crimes. Now, as Jerry can confirm, that period was an absolute nightmare. The local federal court in San Diego just became absolutely overwhelmed. They had to ship in extra judges just to handle the numbers. And it was, frankly, one of the biggest wastes of resources I've ever seen, besides being some of the most cruel policies that this country has ever put in place. I think it's what's shocking to a lot of people is, if I say federal court, I imagine most people think of big white-collar crime offenses and bank robberies, maybe because we're in San Diego, drug trafficking offenses and these gang conspiracy prosecutions. So I think a lot of people are really shocked when they hear that number that Jerry gave just like a few minutes ago, that between half and 70% of the cases in federal court are immigration cases. I think that a lot of people are not aware of that. The other policy that really crippled the ability of refugees to seek any type of protection was something called Title 19 and Title 42, which you might have heard in the news. It was used by Trump to essentially shut down all asylum seekers. Under Title 42, the second of those, it was basically argued that this is a COVID-19 emergency, so we can't let anybody in seeking asylum. Interestingly, just to underscore the hypocrisy of that, the ban only applied to people coming in at the land border, not to people flying in. So I assume I don't need to paint the profile here on the sort of people that have to walk to the port of entry seeking asylum versus the people who could afford to buy a plane ticket. And apparently under the Trump administration, COVID-19 didn't apply to people on planes. But unfortunately, the current administration has kept some of those policies in place. They just announced last week that they were going to be rolling back the Title 19 restrictions. Those are the ones that basically said any non-essential travelers can't come. Those are basically people with visas. But the Title 42 that directly affected asylum, unfortunately, the current administration for now has kept those in place, but there's a lot of pressure to release those. And so with that backdrop, you have the number of Haitians that you heard about in the news last month that were rounded up under the bridge in Texas. And then just the large number of people that still are in these refugee camps right across our border in Tijuana. I think the last thing I want to briefly review for you, apart from the asylum situation, is what immigration court is like. Immigration court in the United States is not an independent court the way we think of federal court or state court. And actually, immigration court is a branch of the Department of Justice. Immigration judges are not independent judges. They're employees of the Department of Justice. And in court, there's an attorney representing the government, a licensed, experienced attorney working for the Department of Homeland Security, for ICE. And then you have the immigrant, who in immigration court has no rights to an appointed attorney. And that includes children, by the way, with some quite shocking accounts of children who have to appear in immigration court by themselves. And by the way, why that matters is that statistically, we know that just with asylum, people who have an attorney in asylum proceedings are 5 times more likely to win their claim for asylum than somebody who does not have an attorney. And a lot of that is because asylum is not an easy process. That the person applying for asylum has the burden to prove their case. And that includes people who are being detained, who somehow are supposed to come up with documentation and declarations and notices and court records from their home country where they're fleeing and they're afraid to go and now they're detained. So it's almost impossible for somebody who's detained, even if they have an absolutely valid claim, to win asylum, unfortunately. Something specific to San Diego, by the way, that the County Board of Supervisors a few months ago authorized the creation of a program to assist immigrants in immigration court. This is something that's happening across the country. A lot of cities in California are doing this, and a lot of cities across the country, New York is doing this. And there's also some legislation in Congress to have some type of federal program to better ensure some type of due process and fairness to immigrants in immigration court. And so that's the overview that I wanted to provide. And I understand that might be a Q&A at the end, but that's my overview. And I believe, was it Aud was going to pick up from there?
Yes. Aud, are you ready to make some opening remarks?
Yes, thank you. Thanks for having me. And thanks for supporting PANA. So I worked at PANA, the Partnership for the Advancement of New Americans. We are a nonprofit located in City Heights. We focus mostly on doing advocacy for refugees here in San Diego. We do work with some asylum seekers. And I joined the team a few months ago as their staff attorney to sort of like help people whenever they have questions. A lot of those questions are about immigration. As you can imagine, my colleagues describe how convoluted the system is and how sometimes complicated it is to navigate it. So the people I work with, many of them are refugees, which means that unlike asylum seekers, they come already with some sort of status. Oftentimes after having spent years and years in camps, in UN camps, waiting to be resettled. So a lot of the people I work with currently are from Africa, they're Middle Eastern or South Asian. And we do work with some asylum seekers, so people who come at the border and ask for asylum. Just to go back on like what my colleague said previously, like the crime immigration is the intersection of criminal and immigration law. And it encompasses everything that basically criminalizes immigration. So it's people being detained and prosecuted at the border for illegal entry or illegal reentry, when many of those people are actually trying to seek asylum, which is an international right. But the other sort of aspect that I think Jerry talked about a little bit is also the consequences of criminal law and criminal offenses and convictions for people who are in the United States and are not US citizen. So you would be surprised because, as Jerry said, oftentimes on TV or in the news, we hear about, like, oh, let's get those like murders and rapist immigrants out of the country. But over half of the people who end up in immigration proceedings because of a criminal, an encounter with criminal law enforcement, it usually starts with like a traffic stop. So many states still have complete open collaboration between immigration services and local law enforcement agencies. And so some people might get stopped for not having the proper driver license or some sort of traffic violation, and from there end up in the pipeline of immigration deportation. And as Andrew said, like there is no immigration provided in immigration court. So unless people are able to afford an attorney or figure it out on their own, in addition to the fact that there are not that many relief that people can apply for, the system is really stacked up against these people. In sort of like the broad, like the wide range of how this come up in people's life, we've had, and especially here at the southern border, a lot of people who have been green card holders have been living here in the US for years and years, sometimes their entire lives, and they end up being deported. One group that was in the news, that has been in the news for the past couple of years, are vets, people who have been fighting in the army, went overseas, and then oftentimes have some sort of PTSD or some issues coming back from war. And then they might end up, having some sort of issue with the criminal justice system, and those people end up being deported. The other thing is, when people are being in immigration proceedings, whether it's because they were crossing at the border, whether it's because they were picked up, somewhere inside the country, those people, in addition to not having an attorney, might sometimes spend years in immigration detention. So in theory, immigration detention is civil detention. It's not there to punish people. It's not criminal detention. And yet it's the exact same thing. In fact, sometimes immigrants are being housed in the same buildings as other people serving their criminal sentence. So for families, it could mean someone is, taken away after serving their sentence. So for instance, let's imagine two people. One was born in the United States, one was born somewhere else and has a green card. Both of them get convicted of the same thing. The difference is the person born here gets to go home once they serve their sentence. The person who was born abroad might end up in deportation proceedings. And that is no matter what a crime was, basically, because under immigration law, it doesn't really matter if someone was convicted of just a misdemeanor or a felony. There's just very different and convoluted categories of crimes that make you deportable. But for that person who all of a sudden, doesn't get to go home, although they have a green card, and end up in removal proceedings, that could mean years in immigration detention. That could mean families where, one of the parents gets taken away. So that's like financial hardship on the kids. And so the ramifications of the criminal immigration go further than just the one person put into the system. One of the other thing is, in terms of like the crossings, the offenses being charged with, like the illegal entry, illegal re-entry, those have been created about 100 years ago, in the late 1920s. And those were clearly for one reason. They weren't to make the country safer. They weren't to make this space more peaceful. It was for one only reason: to deter immigration. That has never worked. And so throughout the years, some administrations just never used this the 1325 and 1326, which are the two offenses. And then some, like the Trump administration, had decided like, well, everybody needs to get prosecuted, which is why also in the news, sometimes we hear this like, wow, there's this surge of immigrants and, they're crossing everywhere. And it doesn't necessarily mean that this is true. Just means that at some point we decided that everyone trying to come would be criminalized for trying to come to the US. And that ended up, like my colleague previously said, about like in 2018, 2019, I think 2/3 of the federal prosecutions were related to immigration. I have many more things to say, but I'll just stop here so that maybe we can open to questions.
Thank you, all three panelists. That was very interesting opening remarks. I know that we have a question in the chat from Dave Myers. Would you like to come on and ask your question directly of the panelists?
Sure, and it has to do with local law enforcement, the Trust Act in California. The inner workings of the U visa for victims and witnesses, and the fact that local law enforcement historically, especially the sheriffs, have allowed ICE and shared information with ICE and how that affects and impacts communities.
I'll start that. Yeah, Dave, this is one of the most frustrating aspects of how immigration law plays out on the local level, because local law enforcement is not supposed to be cooperating with ICE. Essentially, we're not supposed to be using those resources for the federal responsibility of enforcing immigration law. But across the state, including in San Diego at times, we've seen blatant disregard of that restriction, and the sheriffs will notify ICE directly when they know there's a non-citizen detained at one of their facilities. And some of it is extremely frustrating because even when they when they say that they're going to start following the law, which you would hope the sheriff would do, they'll find these little backdoor ways, pardon my language, to screw people. And they'll say, oh, we're not going to notify ICE anymore. But what we're going to do is we're going to create a list of everybody who's about to be released on bond. And maybe that will indicate what their immigration status is. And that's available to the public. So as you can imagine, there's somebody in ICE going through that list every day. So some of it can be very disingenuous. And I don't know if any other two guests have any other thoughts on that.
Odd or Jerry, do you have any further comments on the question?
Just one comment. I agree with everything Andrew just said. I would just point out that some people, and in part, particularly the sheriff, were big opponents of this type of policy. They were like, we want to collaborate with ICE because we do think it makes the community safer. And this is not true. We see that from the states that continue to allow this kind of collaboration. And so I think the act is here to stay, and advocates are working, like people on my team are working on this, and like a lot of immigrant rights activists are working on this. But I would say that also beyond the fact that the sheriff sometimes doesn't want to really cooperate with the act, there are also additional issues that we're noticing in terms of how they're supposed to report this to the Attorney General, and how this information that is supposed to be accessible to the public is in fact not really accessible at all, and how those issues are important for everyone to be aware of and continue to like bring accountability to that, because it's not just about the immigrants who are picked up at that time, but also more than for us to understand what is law enforcement doing, and how they're working with the immigrant law enforcement agencies.
And the other issue related to something Dave mentioned about U visas is when there's collaboration between law enforcement and ICE, it really undermines the trust within the community of working with law enforcement, reporting crimes, reporting being a victim, and that is not good for the community. And so when people are afraid to go to the police because they're concerned that their information is going to be turned over to ICE, that emboldens people to take advantage of an already vulnerable population.
Thank you, Andrew. That's right on.
Thank you, guys. We have another question in chat from Doug Case, asking to discuss the reports this week that the Biden administration will be continuing the Remain in Mexico policy. Is that a change in position or the result of a court determination? The administration can discontinue this policy. What's the path ahead?
That is the result of a court decision. So it is not because of any change in policy within the Biden administration. The Biden administration, there have been some frustrations with the Biden administration on immigration issues, but they have been consistent in opposing the Remain in Mexico MPP program. But because of a court decision, they are technically supposed to not discontinue it because not to get too technical, whenever you change any type of policy in a significant way, it does need to go through some type of process where the community is supposed to have input to changes in the regulations. So the court said that when the MPP, the Remain in Mexico program, was discontinued, it was in a way done too abruptly. So technically, it needs to be reinstated. But I would hope and imagine that it is not going to be robustly utilized by the current administration the way it was in the Trump administration. And eventually, I do expect that it will be discontinued officially.
I have a slightly more nuanced answer to that. Oh, sorry. Just to add to what Andrew said, what's the path ahead? Like, we're just going to keep fighting. Immigrant rights activists have been going to court for years and years now, and they're just going to keep doing this. The Biden administration on its first day said we're done with MPP. And by the way, I don't know if everyone know what this Remain in Mexico policy is, but it's basically a violation of asylum law, where Trump had decided that if people wanted to seek asylum, they would have to stay in Mexico while their asylum case in the US would be completed. So those people would be allowed to come in the US just to go to their hearing, the day of the hearing, and then they would have to stay in Mexico, which would take sometimes years because of the backlog in immigration court. That policy has many issues, and one of them is people were not able to get to their hearing. They were not able to get documents that they were having hearing. And some of them actually were having terrible situations in Mexico. Some of them have reported being kidnapped at the time they were supposed to be in court. So yeah, they couldn't show up to court. But then when that lawsuit a few weeks ago reinstated the policy, the district judge actually used a lot of those factually incorrect basis, saying, well, if people didn't show up to court, it's because maybe they didn't really have an asylum case. And so deterrence is working through Remain in Mexico policy, and it's not. So the next step is the administration just presented a memo yesterday and was meeting with immigrant rights advocates and activists in like how to best implement this Remain in Mexico policy to make it as soft as possible until they're able to actually get completely rid of it. But it's going to take quite a bit of time, I guess. And it's going to be like another couple of months at least where people are going to have to suffer through this policy.
One of the darkest things about Remain in Mexico was how it really took the image of what asylum seekers and refugees go through and tried to hide it, sort of out of mind, out of the conversation. And so I know a lot of us in the community had the opportunity to go down to Tijuana. I actually went out to Texas to Matamoros, across from Brownsville, to look at some of those refugee camps as well. And they are absolutely horrendous. The sanitary conditions are absolutely third world. I can't imagine anybody trying to survive in those camps. Forget about if you have a family with children. It's just absolutely heartbreaking to see what the people are going through, through the winter months and through COVID. It's absolutely atrocious. And the other thing that the Trump administration did as part of Remain in Mexico is they tried to establish the courts in the within the ports of entry. And so they said, everybody needs to stay in Mexico. We'll set up court for you, but it's going to be this special court now. It really was just a secret court. And I, as a licensed attorney, was barred from going in to watch a court proceeding. That is absolutely horrifying, just from a, not to sound too Pollyannish-y, but just from a point of view of democracy, that I can't go into what is supposed to be a public courtroom because they decided to put it on a port of entry base and now say that that's a security issue, and so nobody's allowed to go in. So there were some really, really bad humanitarian, due process, you name it, problems with Remain in Mexico. And so the fact that this thing is not dead with the last nail in the coffin is certainly upsetting and concerning. But like I said, the fight continues there. And maybe technically it's back, but we're not going to let it get very far.
Thank you, Andrew and Odd. Are there any further questions in the audience? Doug Case, I think you have a question. Would you like to pose it?
Yeah, it's a follow-up question to the question I just asked. The news reports indicated they would be continuing to remain in Mexico contingent upon the cooperation of Mexican governments. My question is, what is the Mexican government doing to alleviate the situation at the border with those people that are being returned, either as asylum seekers or others?
Jerry, would you like to take this one?
No. This is Odd's and Andrew's bailiwick, not mine.
Okay.
This is more civil related.
Okay.
When we have criminal questions, I'll get to those.
Okay.
I would say that the main problem with that question, Doug, is it's not so much what is Mexico willing to do, but what are they capable of doing? And they just don't have the resources, the capability, the manpower. And if you look at the best those camps ever looked in Matamoros and in Tijuana, if that's the best the Mexican government could do, then I mean they can say that they are planning to cooperate all they want, but they haven't been able to provide much assistance, and so the people that have the most influence there are unfortunately the gangs and the cartels and the smugglers, and a lot of the Mexican police themselves are often afraid to go into these facilities because they are being operated by criminal organizations. And I don't know what else to say other than, a lot of the people that are fleeing Latin America are Mexicans themselves because of the corruption of the Mexican government and Mexican law enforcement. So I'd be cautious about putting too much stock into pledges of Mexico to provide support. I do think that there are some good faith efforts to do it, but I just don't think that they have the capability based on what we've seen so far.
Yeah, it sounds like a human rights disaster to me.
Well, it is. And actually, this is where this could be a loophole into like ending the policy, or at least not really reinstating the policy, because I believe the memo mentioned that Mexico has to be cooperating for MPP to work. And so I guess there could be some just political move from Mexico saying, we're not going to be part of this anymore. I doubt they'll do that, but one can always be hopeful.
Thank you for that.
I also think a lot of what Mexico did in the Trump administration was because of a lot of the pressure that Trump put on the Mexican government, basically threatening them that they better cooperate. I would hope that we now have a better, more respectful relationship with Mexico, that they wouldn't feel compelled to participate, like Odd was mentioning.
Thank you both. I think Angela Hawkins has a question. Would you like to pose it?
Yes. So with regard to the fact that there are laws that have essentially set up this situation where so many people are being charged criminal action when it's absurd that that's actually happening, is there legislation that could be supported that would be able to change this? Or is this going to require a major overhaul in immigration law, which seems to have been bottlenecked for years? Do you have any hope either on the local level or on the federal level?
Want me to take that, guys?
Sure.
I was going to mention, I'd mentioned earlier that the 1325, the illegal entry law, was enacted around 100 years ago. She's right. It was, I believe, sometime in 1929, early 30s. And it was, I just wanted to, before I forget, it was directly targeted at prosecuting Latin Americans because European immigrants and Asian immigrants, their immigration levels were limited by quotas and bans. And so these illegal entry laws were directly targeted at Latin Americans. And the number of prosecutions, it was fairly high when the law was first enacted, up until about 1940. And then it dropped down to a very low level, where people were not really, like Lod said, the federal government was not using this law to prosecute people that much, up until about the Clinton administration, and then it really went increased during the Bush administration, and it's been pretty consistent since. But I think one answer to your question is a big factor here is the prosecutorial decision by the Department of Justice and how many people they decide to prosecute or not prosecute, to bring the levels more in line with who should really be prosecuted the most, the people who are violent or those low level numbers that we see of the very people who have very serious criminal offenses in their past. I think that's more realistic to think that would happen than a legislative change, but I'll let my colleagues discuss that.
So on the legislative side, on the political side, since it's a Democratic club, I would direct your attention to people like Julian Castro. Julian Castro has spoken directly on the use of these 1325 and 1326 statutes to prosecute people. And so it's going to take, people like him to make this an issue that gets some type of leverage in Congress. I mean, these are federal laws. And so if there's going to be a change, it needs to be made on the federal level. And that, I suppose it can be done two ways. One way would be what Jerry was referencing, and how the prosecuting agencies, like the U.S. Attorney's Office, decides as a matter of discretion how to use these statutes and whether to use these statutes, but also on the legislative side about whether this can be either part of a larger package of immigration reform or just address the history of 1325s and 1326s and get Congress to say, maybe this isn't an appropriate law that essentially is being used to criminalize civil immigration matters.
Thank you for that. I think there's a couple more questions, Dave. I think there's questions from Dave Myers. Would you like to pose those questions, Dave?
Sure. And I think Jerry was the one talking about criminal law, and it has to do with if he has a frustration with the ability, since local law enforcement comes in contact with lots of immigrants who may be victims and or witnesses, with the lack of policies and practices of local law enforcement to ensure U visas are afforded to those individuals. And also, any of the panelists have any comments on the 287G program?
I'll give that to Andrew or Odd. I mean, I think that's more of a civil law question with the U visas and witnesses and things in that nature.
Yeah, with the U visas, I think that one thing that's happening in California is, out of Sacramento, there have been attempts to really encourage law enforcement agencies to be more open to participating in the U visa process. To those who don't know, a U visa is a visa for somebody who's a victim of a certain type of crime and has suffered some type of injury and cooperates with law enforcement. And so the most common would be somebody who's a victim of certain types of domestic abuse or assault. And so those individuals, to encourage them to report their crimes and to assist law enforcement, they can be eligible for a certain type of visa called a U visa. It requires that the police or some office certify that they cooperated with law enforcement. And so there has been some inconsistency across California. Certain cities were known to be more open to signing those certifications, and others have been much more stingy. And so out of Sacramento, there have been attempts to basically say, listen, law enforcement, listen, sheriff offices across California, if somebody comes to you and is a victim, you should be encouraging them to participate as a witness. You should be encouraging them, and you should be signing those certifications that is not granting them any type of immigration benefit, just confirming that they did what they needed to do with law enforcement, and then they can then take that and try to get this U visa. And so I think that there is a role for law enforcement in being more liberal in granting the certifications for U visas. And in terms of education, I think most of the education, I think Aude would probably speak to this more, comes from a lot of community-based organizations that work in the community to let people know what their rights are and what their options are and about the U visa. Because otherwise, I don't think we can rely just on law enforcement to be educating people in the community and advocating for them to actually apply for U visas. That might be, not the most appropriate ask of law enforcement directly.
Yeah, one thing I would just add also with the U visa is that the process is pretty lengthy. So even when law enforcement actually agrees to certify the documentation for the U visa, there is a backlog. I think it's only 10,000 U visa per year that can be issued. So for people, it doesn't necessarily give them immigration protection or relief right away. But this is definitely an option that is helpful for many people who still want to report the crime and assess law enforcement. But definitely there is a lack of information for people knowing that they could be eligible for that relief. So yeah, I guess, if law enforcement agencies were more interested in sharing that information with people, that would be great. But I think right now it mostly comes from nonprofit organizations.
Thanks. I believe Gary Gartner has his hand raised. Would you like to pose your question?
Yeah, it's more of a comment about the U visa because I've experienced personally trying to help a friend in the Bay Area who was attacked over a year ago in East Oakland and got the U visa, got the police department in Oakland to sign for it. I helped him through the whole process. And we worked through Senator Feinstein's office and this, that, and the other. And it's just, the immigration system is so effed up in this country. It's maddening. It makes me very angry to try to help this guy. So at any rate, they're years behind in issuing these U visas. And so, I talked to Feinstein's aide and said, he's trying to be legal in this country, and our country's going to force him to, break the law, work illegally, whatever. He's used all of his savings from Bangladesh, where he's from. So now finally, it seems that the Biden administration has pushed to help more people. So he's actually gotten his fingerprinting and stuff done. So we're hoping that sooner than later, he's going to be able to actually get that U visa. But it's really crazy. That's all.
Thanks, Gary. There's a question in chat from David Mosley. Would you like to pose it?
Yeah. Are people facing trial or court for immigration concerns in general able to be referred for competency evaluations if they seem like they don't understand the proceedings? It sounds like the immigration system is a little different. And then, Jerry, are you able to refer your clients for criminal matters for insanity evaluations as well?
Yes. In order for someone to be brought to trial, they have to be deemed competent to do so by the court. So if an attorney feels that his client is not competent to do so, then it's that attorney's responsibility to bring that to the court's attention and to have his client evaluated for competency. And competency means, under the federal law, they have to know the charges, what they're being charged with, the consequences, and able to properly assist in their defense. And so, yes, if someone's charged with illegal entry or reentry, and we feel that they're not competent to proceed due to a mental illness, then we have that responsibility to have them evaluated. That's pretty rare. We don't see that often, especially with those cases. That's typically the more bank robbery type of cases where, these guys are very mentally ill. But it occurs. I've seen it every now and then, but it's pretty rare. But I'm not sure about the immigration. I'll let my colleagues talk about the immigration proceedings.
Yeah, in immigration court, as we were talking about earlier, people in immigration proceedings have no rights to appointed counsel. And that, for a long time, included people with significant mental health issues. And it took a case, it was a class action suit called Franco v. Holder from, I believe, 2018, that went all the way to the Ninth Circuit Court of Appeals, where the Federal Court of Appeals for the Ninth Circuit finally said, this is ridiculous. People who are incompetent, who are not even entitled to an attorney, cannot represent themselves in these complicated deportation proceedings. So in a very small group within the Ninth Circuit, which only encompasses certain states, there is now a requirement that people with significant mental health issues who are detained and in immigration proceedings be given an evaluation and be given some type of legal assistance. That is now being expanded to other parts of the country, but it is still one of the very few areas where people in immigration court can now get legal assistance.
So I'd like to pose a question myself here, since there's none in the queue at the moment. So what happens when a person is charged with an immigration crime? Do they just go to prison? Do they just get deported? I mean, what is the typical outcome in court?
What's interesting is that when they put into place Operation Streamline and Zero Tolerance that mostly Jerry was talking about earlier, a lot of these individuals were people who were coming into the United States specifically to apply for asylum. So instead of coming to the port of entry, as they're allowed to do under U.S. law, and saying, I have a fear, I want to apply for asylum, and letting them come in and make their case, they were not being allowed to even ask. They would be being put in these desperate situations, and many were crossing over without permission through the desert and caught. And even if it was clear that they were there to request asylum, they were put in federal criminal custody, referred to the U.S. Marshals, referred to the U.S. Attorney's offices, and prosecuted for illegal entry or illegal reentry cases, and many times having to do custody time. And what happened at the end of that? They were then transferred to immigration custody so that they can apply for asylum, which is what they wanted to do in the first place. So that is one of the, Kafkaesque type nonsense that we saw during the Trump administration, a lot of which we still see now. But people who are just fleeing for their lives often have to deal with the criminal system first, and then hopefully be given an opportunity to request some type of immigration relief, such as asylum, once that's over.
And if I could just piggyback on that too, the other Kafkaesque situation that Operation Streamline caused is that, remember, there's a finite amount of resources that we have. And when you prosecute more people for illegal entry and reentry, that's taking away resources from the other cases that people would typically think would be more serious, namely drug offenses. So what we saw is a lot less drug smuggling offenses being prosecuted in federal court because all these illegal entry cases were taking up, the court space, the jail space, the holding cells. And so, in essence, it was benefiting drug smugglers to have these zero tolerance policies. And in effect, a lot of these cases were being transferred to South Bay Court for prosecution, but that overburdened that system as well, and they were facing much less sentences in state courts and federal court. So that's another ramification of this so-called zero tolerance policy.
Wow, crazy. So do we have any further questions from the from the group for our panel?
I have a follow-up question.
Okay.
So if when somebody's facing immigration court, so not Jerry's scope of things, if they're not entitled to an attorney, are there concerns about competency being accurately, like questions of competency being accurately reported or brought to concern if it's just a judge and the opposing side's attorney? Are there times when nobody says anything because it's going to speed stuff up because there's so much going on that, it takes forever to get a competency evaluation anyway?
Absolutely. I mean, anybody who knows anything about people with mental health issues knows that it is not something that manifests itself the same way in every moment. And so to say that, okay, you're entitled to an attorney or some type of legal assistance if there's evidence that you have a mental health issue, that's exactly the right question. Well, who's making that decision? And essentially, in many cases, it's up to the immigration judge who's trying to juggle cases every day to say, hey, that guy seems like he might be suffering from PTSD or schizophrenia. These are immigration judges. They're not mental health experts. And so I have absolutely no doubt that there are many people falling through the cracks that have significant mental health issues that nobody would catch because there's no appropriate mechanism to identify these individuals to basically put them on that track to begin with. So there's still a long way to go.
One thing I would add to that is also that in immigration court, when people don't speak English, which is the majority of people, they are entitled to an interpreter providing by the court. It's often someone over the phone. And this is also just a whole mess itself. So judges are not necessarily culturally competent. They're not really trained into understanding how customs work in different countries. So sometimes you see something as a person and think something is going on, but then really the person, the immigrant, was trying to say something else. The interpreter didn't catch that. So there is also all this barriers around it that make it even more complicated for those who have competency issues because they might not be even able to raise that as an issue.
I believe Angela has her hand raised.
So as we mentioned earlier, we are a democratic club, and often our members like to be able to do things to help support good work or whatever we might be able to do in response to this challenge that is presented to us. So do you all have suggestions as to what our club members might be able to do? Are there organizations that need donations? If you could speak to that.
From a political point of view, I would say that showing your support to the County Board of Supervisors for their initiative to fund a program to provide services to people in removal proceedings, I think that is something that would be very welcomed by our elected representatives, because usually the only people that show up to these meetings are people that are, screaming and spitting about, how they're being treated unfairly and where's their money going. And so I believe Nathan Fletcher is the supervisor for OB in Point Loma, I believe. He was very much in support of that. I believe it was, I don't want to misstate anybody's position, but the majority of people on the County Board of Supervisors supported this. I know Nathan Fletcher was one of them. And so letting them know that you support that initiative, when you see that there's a council meeting, think about maybe writing in a comment or phoning in to express your support for that. I think would be great. And I think that from a practical point of view, maybe Odd being more tied into community-based organizations has some suggestions for that way you can help as well.
Yeah, definitely showing up at the Board of Supervisor meetings is important. City Council meetings when they have some topics on immigration. Overall, just being informed and trying to be, informed with the real stuff and not the misconceptions. That's already something that's huge. A lot of our work oftentimes is just talking about misconceptions and things that people misunderstood because it's hard to get reliable information. volunteer if anyone has time and you're interested, like, most, at least nonprofit organizations, they can use the help if people want to do some sort of research, working with people. There are ways to get involved at the local level, especially now with the Afghan crisis. We are getting a lot of Afghans resettled in San Diego. So there are plenty of ways you can just get active in the community. You could have just a little roundtable conversation to help other people understand. There are plenty of ways for you to get involved.
Okay, do we have any other questions in the group? Okay, well, I think we went just slightly over time, and I'd like to thank Jerry, Andrew, and Odd so much for your time today and explaining some things that are definitely not well explained in the media. So thank you so much for your time.
You're welcome. Thank you for having us.
Thank you.
Thank you for having us.
If you enjoy this podcast, consider becoming a member. More details are available at our website, pointlomadem.org. The Point Loma Democratic Club is one of several clubs of the San Diego County Democratic Party. More details are available at sddemocrats.org.